My firm assists people with their divorce, paternity issue, or adoption in a manner best suited to their needs. Today I'm going to tell you a little bit about divorce. Divorce proceedings fall under two general categories, contested or uncontested. When a divorce is contested, it can be handled in several ways. Traditionally, they are litigated. This involves going to court and fighting it out. However, there is another option, the collaborative divorce process. The collaborative divorce process is governed by the Florida statutes. The law was enacted to create a unique, non-adversarial process that preserves a working relationship between the parties that reduces the emotional and financial toll of litigation. So what is the difference between collaborative and litigation? A litigated divorce is not a pleasant process. It begins when one of the parties files a petition for dissolution of marriage. A summons is issued by the clerk of court, and a process server will serve the spouse with the summons and the petition. This may be done at the spouse's home or workplace. The spouse then has only 20 days to file a response. They may also file a counterpetition with their answer. Once all of the pleadings have been filed, each party has 45 days from the date of service to provide the other party with a large number of financial documents. If they do not do so, then the attorneys go back to court to have the judge order the other side to comply. If they still do not do so, then the parties can be sanctioned and held in contempt. There will often be numerous communications between the attorneys, but very little between the parties. At some point in the process, the judge will order the parties to mediation. Often, this is the first time that the couples have actually sat together to discuss what they want. Depending on their attorneys and the mediator, the success rate of mediation varies. If the attorneys just want to fight it out, it's unlikely that the parties will come to an agreement. If mediation is unsuccessful, then the parties go to trial. It is a lot like trials you see on TV, where the attorneys call witnesses and question them, but there is no jury. Divorce cases are always heard by the judge. At the end of the trial, the judge makes the decisions for the couple, including all of the property division and parenting issues. So, in other words, a person who has known you only for the length of your trial is going to make decisions that will affect the rest of your life, and the lives of your children, too. The collaborative process, on the other hand, while not necessarily pleasant, is a lot less stressful. The process can begin before any case is filed in the courts. It is required by law that each of the parties have an attorney. While it is not required that the attorney have any special training or certification, the process is more likely to be successful if the attorney has at least some training in the collaborative process. Litigators want to argue, that's what they do, but for collaboration, they need to turn that off. The collaborative process involves a team which is made up of the parties, their attorneys, and usually two neutral experts, a facilitator who has a background in mental health, and a financial neutral who is usually a CPA or a forensic accountant. The team will meet together several times, and occasionally the parties will meet with just their attorneys or the experts, depending on what they were working on. For instance, if they are trying to develop a parenting plan, they may just meet with the facilitator. This keeps costs down and makes the team meetings more productive. During the first team meeting, all of the participants will sign a participation agreement which spells out the issues that will be decided and the documents needed to decide those issues. There are also rules which will be discussed. For instance, if one of the parties goes to court for any issue pertaining to the divorce, then the collaborative process is finished and the attorneys must withdraw and cannot represent the parties in any future litigation. The experts will also cease to provide any further assistance to the couple. In family law, the issues are represented by the PEACE acronym. This stands for parenting issues, such as parental responsibility and time sharing, equitable distribution, which is dividing up the parties' assets and liabilities, alimony, or spousal support, child support, and everything else. In a litigated divorce, this usually pertains to attorney's fees. That may also apply in a collaborative divorce, but it can also mean anything else that is important to the couple and that they would like to have addressed. As you can see, the two biggest categories of issues are children and finances. This is why it is good to have some neutral team members who are experts in these areas, such as the facilitator and the CPA. There is no trial in a collaborative divorce. Once the parties have come to an agreement on the issues, then the attorneys will draft the necessary documents to finalize the parties' divorce. There will be one time that the parties appear in court, and that is the final hearing. The appearance is short, and they will only have to answer a few questions. So, besides reducing the emotional and financial tolls on the parties, what are some benefits to collaborative law? The process is often quicker. The proceedings are private. The parties are happier with the outcome and more likely to comply. And the team can think outside the box and use agreements that would not be ordered by a judge in a trial. There are a few potential drawbacks as well. The cost may be higher up front because 4 retainers may need to be paid. However, the entire cost usually ends up being the same or lower than what is paid for litigation. If the parties decide to quit and go to court, then they lose their attorneys and experts and will have to hire new ones. I hope you can see how the collaborative process is much better than litigation.